Your Honor, before the next step, we'd ask that the jury be asked to step out and we bring a matter up.
Okay. All right, ladies and gentlemen, let's go ahead and take we'll plan on 15 minutes, 15-minute recess.
All right, for the jury. Please proceed.
Your Honor, because the defense of Travis and Greg McMichael has been joint in many ways, before there is any resting that goes on, I wanted to revisit and make sure that we have perfected the record on several issues, especially now given the additional evidence that's come before the court concerning the issues of mental health, the issues of Ahmaud Arbery being on probation at the time of this event, and the use of force expert, all three of which this court has prohibited our introducing evidence on. So if this works okay, we haven't actually worked this ballet out here, but if I could, the mental health evidence was prohibited by this court. But since that time, you now have testimony from Travis McMichael where there have been complete descriptions of behaviors and conclusions drawn from those behaviors by Travis McMichael that are consistent with a number of the things that were reported in the Gateway records and would have been corroborated and explained even further by Kelly Kaufman, who was our mental health expert. So I can do each of these, or I can lay out the new information that we asked the court to consider. Would you prefer that I go by each?
Well, once you get through it, then I'll try to address it in the
Very
same way.
good. Thank you, Your Honor. Second, we had also sought to introduce evidence that Ahmaud Arbery was on probation under 2 felony offenses. A great deal of exposure still left on those. The court denied that motion. I point out that in the state's case, the medical examiner was permitted to testify about fight or flight, and even after objection was permitted to give his opinion concerning fight or flight and cortisol, etc., as being the explanation in his mind for, under the state's questioning, the decision to make a sharp left versus a sharp right out of the neighborhood. Number 2, with respect to probation, under the cross-examination of Travis McMichael, he was cross-examined by Ms. Donikoski at several points for quite some time about it, in a way that indicated that the state's position found it to be incredulous that Ahmaud Arbery would just have run back at Travis McMichael at 2 different occasions, and then certainly that he would have directly run at Travis McMichael to engage in a behavior that is otherwise unreasonable. So for that reason, we would ask that the court reconsider and allow us to introduce evidence of Ahmaud Arbery's probationary status as further explanation for why fight or flight, while that is the state's theory for taking the sharp left and attacking Travis McMichael, may have been to avoid being apprehended by the police and again having to do time or face further investigation for his probationary status. And third, the use of force expert. We had asked for a use of force expert, or primarily the Travis McMichael team, to explain to the jury the theories that Travis McMichael did a very good job explaining on his own. However, once he explained them, he was cross-examined by the state on the way that he implemented that training, and even at one point an exhibit from his training was placed on the Elmo, if that's what it's still called. I don't know if that's on the screen. On the on the screen for the jurors concerning some of the training and the ways that Travis McMichael would have made decisions on that training. Because he was cross-examined, I believe now the state has opened the door for the use of force expert and testimony to come in to provide the support necessary to corroborate his testimony for which he was cross-examined. So while we do need rulings on those three, given this additional evidence in the state's case and the defense case, we also need to perfect the record for a proffer, as a more complete proffer as to what the mental health evidence would have been. The court is aware, because of the records that we submitted, of Ahmaud Arbery's probationary status. I believe you have those records already. And then I need to just inquire of Travis McMichael's team as to whether the use of force expert testimony has been properly proffered as to what he would have said had he been allowed to testify, and his credentials.
And I think the gateway records, and I'll have to look, but the gateway records were reviewed by the court and then sealed into the case.
Correct.
Okay, just want to make sure.
Yes, I believe that is the case, Your Honor. And of course, there are a few other things that we're going to make sure are in the record that doesn't change much now and doesn't require us doing them before anybody rests. You know, some of the note, I'm sorry.
For the record, we would join in the three issues that the McMichaels have raised before we move on to something else, if that's okay. All I would add, Your Honor, is maybe I missed it, and I certainly don't mean any criticism. I think I owe the court a few things, but I don't think I've seen or been served with a copy of the court's order on the probationary status ruling, and honestly, I was waiting for that so that I could move to reconsider. But it's hard for me to move to reconsider when I don't actually have the reasoning of the court on that. So I hope the court would allow me that opportunity in the morning, assuming that sometime before 9 a.m. the court enters an order on that. You've orally indicated that you wouldn't allow it. You've indicated that you would follow up with a written order, kind of like I promised I'd do a bunch of things. And I'm still working on those. It's not a criticism, but I was hoping to have the court's written order before being in a position where I had to either move to reconsider or waive the issue. So I'm not only joining in that, but I'm humbly asking the court, if the court can, the court's under no obligation to enter a written order, but my understanding was the court gave us a short summary of its reasoning with the representation it would follow up when it had the opportunity. Because the court hasn't had anything else to worry about during this trial. When the court had the opportunity, I would like the opportunity to move for the court to reconsider when I have that written ruling.
And I was through with those three. I just wanted to let the court know that we will perfect the record with some of the other things we agreed to place under seal, one of the notice of filings, and then the Facebook records with respect to some of the cause strikes that we had made. We all agreed to get those under seal. I just haven't gotten that done yet.
There are a number of things probably to go through at some point, make sure everybody's on the page with what those items are, just to make sure that the record is complete based on what everyone understands either has been or has been promised to be submitted. Okay.
Thank you, Your Honor.
Thank you, Judge. On the subject of evidence that we feel the court should reconsider before we have to decide whether we're closing or not, the 404B evidence that we had submitted to the court, where we heard a lot of testimony from uniformed officers. We heard testimony from a uniformed officer in a park setting where he approached to try to speak to Mr. Arbery about some suspicions that he had about Mr. Arbery and how that de-escalated into confrontation. We heard that it escalated into confrontation, excuse me. That officer was dressed in uniform with badge and gun in a marked patrol car, and that still happened. We have the encounter in Burke County where Mr. Arbery was chased out of an abandoned building where they suspected marijuana use. He was shouted at, told to stop running, come back, police, by an officer in official clothing with badge, gun, police cars, and did not.
So, the submission of evidence, I mean, I think there were 10 separate incidents submitted, of which the court has addressed in the order, and we received evidence through hearing. That's all part of the record.
Okay.
So I mean, I understand which motion you're talking about.
Got it.
The items
Thank
are-
you, Judge. So what we've seen then in the case, and the reason why we're asking the court to reconsider this evidence now, and we want to limit it to it wouldn't be all 10 things, it would be things that speak to this particular issue, which is the state has asked all law enforcement officers about their manner of dress, their clothing, and how they use that for presence and to talk to people and make arrests, and to try to, I think, distinguish what they did with Mr. McMichael, which is you were not in uniform, you did not have a badge, you were not in an official car, you didn't have any official looking presence. And they also questioned Mr. McMichael about, Mr. Arbery has no obligation to stop and talk to you. He has no obligation to speak to you. He has no obligation to explain himself. He can run away from you, and you weren't wearing a uniform and badge, etc. So this has made now relevant the fact that for Mr. Arbery, for Mr. Arbery in particular, when an individual approaches Mr. Arbery and questions him about his conduct, he doesn't engage in a typical fashion. He runs or he gets combative or confrontational, and we have evidence of that over the timeline which we've submitted to the court. The state has now presented this evidence to the jury through the questions and answers, and I guarantee you will argue it in closing that Travis McMichael, dressed as a plainclothes person, Mr. Arbery had no obligation, and thereby essentially create this chasm. The jury should be made aware about the 404B evidence for the purpose that it is limited for, which is to show motive and intent. They're going to get into his intent, and have done so already, by opening the door on several other occasions, talking about an opening statement being an avid runner, talking an opening statement about Nike shoes so worn that the tread was worn off, that he ran off on his jog toward the McMichael's house, that he never stole anything, he never took anything. Through Matt Albenzi, they questioned him, saying, you don't know why he was in the house, sort of baiting the witness. You don't know why Mr. Arbery ran, introducing the issue of his intent in the house or him running. They actually brought Kelly Parr to testify, and she even talked about his behavior and his intent and what he did not do, like ducking or hiding or running away, that he just stood there. Again, putting his conduct into the case. The 911 call, they allowed Larry English to testify that he looked like he was drunk or on drugs or disoriented. Officer Rash was allowed to testify that he was trying to figure out why he was coming there at night. That's what Rash testified to. Your intent, Officer Rash, was to identify him and find out why he was coming there late at night and then trespass him. Again, the state is putting in Mr. Arbery's intent through the officer, now trying to say, we're trying to actually figure out what his intent is there that night, making the intent issue relevant. And that Officer Rash took action throughout the entire neighborhood to find out why he was there, riding around, asking people, do you know why he's here? They asked the question about, do you know of his routine? That was objected to and sustained, so that's not evidence. They tendered the photograph of the sneakers, the top and bottom. So all of these things are getting into Mr. Arbery's intent, Your Honor. And it goes beyond where the court wanted us to be, but this is all through the action of the state. And so we would say now that his intent has been put in through their opening statement, as well as their law enforcement officers and some neighborhood witnesses. Notice, we didn't ask any of our witnesses, did you see him, did you know him, does he run in the neighborhood? We didn't ask that, but they did. And so for that reason, it reopens the door. It opens the door for 404B, and we would ask you to revisit it because of those things.
And Your Honor, I would join in that motion for reconsideration as I joined in the original motion. And I will add this. I don't understand how the state can be pursuing a theory of aggravated assault that's based on the fear of Mr. Arbery, which is going to his mental state at the time that he's being chased, without opening the door to any facts or circumstances that inform his mental process there. And we can certainly take that up at charge conference. That's been noted to the court. But, I mean, if the state is pursuing an aggravated assault theory that is based solely on intent to injure, intent to assault, that's one thing. That's the mental state of the defendants in this case. If the state is pursuing an aggravated assault theory based on the reasonable fear of Mr. Arbery, then these other circumstances are certainly informing his decision as to what he's doing. And I think the court should require the state to make an election as to what theory they're proceeding under before the court ultimately rules on the 404B issue. Having said that, as I said, I've joined in the motion.
Anything from the state?
Yes, Judge, the state asks that you deny these 4 motions for reconsideration on all of these issues. All of this was known before we ever started. The mental health is totally irrelevant. 401, 403, they didn't know Mr. Arbery. 404B evidence on Mr. Arbery, they didn't know Mr. Arbery. So therefore, the same rulings and orders you've entered apply right now, despite all the evidence that has been put up. There is absolutely nothing about his mental health, given that Travis McMichael didn't know about it. But Travis McMichael took the stand and told the jury his perceptions and what he thought about Mr. Arbery. So that evidence, based on his perceptions, is before the jury. Probation with fight or flight. Actually, at the end of Mr. Travis McMichael's statement, it was fight or flight. He actually said that. I assumed the defense was going to ask him about that, and then they didn't. Blaming the state for cross-examining their client is a bit of a ludicrous argument, because the state's position is Travis McMichael is lying, not that it's incredulous about Mr. Arbery, that Mr. Arbery would do this, Mr. Arbery would do that. What's incredulous is the lies Travis McMichael is trying to tell this jury, all the stuff he's come up with. That was what the cross-examination was about. The use of force, he got up here and talked about his use of force. He explained it. He did the continuum. Mr. Rubin had him talking all about it. To say the state, once again, cross-examined about it, so now we've opened up the...
It was actually Mr. Sheffield. Out of one direct.
Thank you.
You're absolutely right. It was Mr. Sheffield. But to blame the state and say, well, you cross-examined our client about what he's telling the jury about use of force, so we get to bolster his testimony now, we ask that you go ahead and deny that as well. And there is absolutely nothing that the state's done to talk about Mr. Arbery's intent. We talked about Officer Rash's intent as a law enforcement officer. That's what we talked about. The 911 call, they stipulated to the 911 call where Larry English goes, oh yeah, this is what he looks like out on the boat. And yet they're complaining. So, Your Honor, your orders that you entered on all 4 of these issues, your oral one on probation, we ask that you deny their motions for reconsideration based on the evidence that has been presented here. Thank you.
Any final word then, Ms. Hook?
Your Honor, I stand on what we said. It's not an issue of blame. It's an issue of what proof came in that might inform the court in seeing this in a different light than you did before the evidence that you had an opportunity to see.
Before the court then, our motions for reconsideration on the 4 evidentiary issues that were brought up. There is an existing order on the, I'll just refer to them as the gateway records. I forgot I don't have it right in front of me, I forgot how that was couched in the order, whether that was the character, I think it was actually the state's motion in limine on character, which then resulted in a number of filings. That existing order has been in place. Considering the motion for reconsideration, the court is not going to allow those records to come in. The probation and use of force expert orders will be to come. Those are in the process of being drafted. Mr. Goff, they will probably not be in a form that will get them filed by tomorrow morning. But what I tried to do, and I do remember doing, at least on the probation order, was lay out where the court's opinion was based and how the court reached the conclusion that it did based upon the evidence presented at trial. The court's not going to reopen either of those two matters. And then, as with the first issue, there is a written order on the 404B evidence, which are the various things that Mr. Sheffield was just referencing. And again, the court on the motion for reconsideration relies upon that order and has considered the evidence referenced during trial and is not going to reopen that matter. So for the record, I think that should clear the record up. If there are matters that need to be placed into the record that have been referenced as being sealed into the record or need to get into the record, I'll keep the record open. I'll figure out the best time to do that until, which I understand then would be documentation that we have discussed before the court that just needs to be part of the file. I would imagine we'll keep that open probably through, I would imagine through closing, maybe to closing. If that's a problem, why don't everybody let me know what needs to come in and how long it's going to take to get it in. Maybe that's the better way to do that. I'll keep the record open. Okay.
And at the appropriate time, I did have a couple other things to add.
Let me make sure with the McMichaels.
Oh, I'm sorry, I'm not interrupting, I didn't know if you.
No, I was waiting on you all.
I do think, in order to perfect the record, certainly on the use of force expert and perhaps Dr. Kaufman, that we would like the opportunity to call Rick Register, who's a former ATF agent, FLETC instructor on use of force, to make the proffer. I think.
To be the one producer report?
No. They didn't do a scientific examination, so there's no.
Just throwing it out there.
Yeah. But we do need to put in the record what he would have said had he been allowed to testify.
Okay, well, let's figure out, when are they available?
I can inquire tonight and get back to the court, but I think Mr. Register is very flexible.
Dr. Kaufman's a different story. So I've checked in with her, but I'll speak with her and get back to the court as well.
Yeah, I mean, I can't keep the record open forever.
No, we could do it this weekend or next week.
Anything then further from the McMichael defendants?
Yeah, no, we'll rest when the court brings the jury back.
All right. Mr. Goff.
Well, Your Honor, I'm so sorry. I think for the record, we actually need to hear from Greg McMichael personally, just to make sure it's on the record.
It's on the record, we don't need to hear from him.
And I guess I did hear from counsel for Travis McMichael, counsel for Greg McMichael. I understand you're adopting it. I think it had been placed in the record before. Well, it would have been placed in the record before that Greg McMichael would be, I can't remember the language that was used, but effectively adopting the defense. But if there was anything else that may come up, then that would be presented. So what I understand is there's not going to be any additional evidence presented on behalf of Greg McMichael.
Well, what we anticipate you would do, Your Honor, is when the Travis McMichael team rests, you would call on us and then we would make our announcement.
Yeah, and that's just I'm trying to make sure I understand what we're doing.
Right.
Yeah. And so then Greg McMichael will rest, as I understand it, and then it'll be to Mr. Bryan.
I'm so sorry, Your Honor, not to be really, really picky, but being an appellate, at this juncture in time, Greg McMichael has not stated on the record whether he's going to testify or not. And he has not put his decision on the record. So if the McMichaels rest, the problem is a clever appellate attorney is going to come behind and go, Mr. Greg McMichael never was given that. I'm just.
And that's fair, because as I indicated, I'm usually used to defendants in the discussion with the court on testifying, saying whether they have or haven't. And actually, in this case, he hasn't said whether he intends to testify. It's my understanding that Mr. McMichael does not intend to testify and intends to rest.
Well, Your Honor, we'll announce that when you call on us to present our case, but yesterday, I believe it was, you made the full and proper inquiry about whether he understood his rights.
And I think we might be talking in circles at this point.
Yeah.
I think we're all in the same place. We just
I
need
don't
to clear
think
it
we
up.
are.